Okay, I think we're probably safe to get started here now. Once again, thanks again for joining us for our webinar this afternoon on hiring and onboarding new employees. Should be a really good presentation with lots of good info for you guys. So yeah, let's jump into it. Those of you paying keen attention have probably noticed that I'm not Randi Collins. Something emergent has come up. We're requiring Randy's attention this afternoon, so you are stuck with me instead. My name's Colton Herman. I'm a associate here with Getz, Collins and Associates, and presenting along with me is Christin Elawny. She's a senior labor and employment associate with Getz, Collins and Associates as well. So just as a quick primer on what we're going to cover today, we're going to start off by discussing, some key considerations when advertising and interviewing for new positions, new employment positions. There's a few different pitfalls that can happen there, and good things to keep in mind. Next, we'll move on to, what makes a strong employment contract. That is a pretty expansive area, which could probably form its own hour-long presentation, but we will give you some of the key points to keep in mind as you're going through that process. We'll then move on to employer policies, what some of the most common policies are and what those should include, as well as some tips for implementing those in a way that's effective and enforceable. And then lastly, we will finish off with a section on onboarding new employees and some key considerations to keep in mind there. Now, as we're going through this, if you have any questions, please feel free to submit them to the Q&A, and we'll also be sure to leave some time at the end to address those. Yeah, let's dive into advertising and interviewing for new employment positions. So one thing that often comes up is whether or not there's a need to disclose the expected wages when you're advertising for a new position. In Alberta, there's currently not a strict requirement by law to advertise the expected wages for new positions. That being said, it may help attract candidates to those positions because people do like to have some transparency in that regard. So it could be good to attract talent that way. That being said, we have seen a bit of a trend in Canada where provincial governments are starting to require the disclosure of expected wages in new employment positions. Legislation has already been put in place in BC, Ontario, and Prince Edward Island requiring this to occur. So it could be something that's coming down the line in the future in Alberta, but as of right now, it's not a strict requirement, just something to keep in mind. Another really important thing to keep in mind when we are doing advertising and interviewing for new positions is that human rights law still applies during these processes. Despite no formal employment relationship existing yet between you and your potential candidates, the Alberta Human Rights Act does apply to all employment practices, which includes the interviewing and advertising processes. So it's important to keep this in mind. Otherwise, you could potentially face penalties from the Alberta Human Rights Commission, as well as reputational damage for human rights violations. Now, the Alberta Human Rights Act describes 15 unique protected grounds which apply during the employment practices that I'd mentioned. So this is a long list here, but physical disability, mental disability, religious beliefs, family status, marital status, race, color, gender, gender identity, gender expression, age, ancestry, place of origin, source of income, and sexual orientation are all protected grounds which employers must avoid discriminating against. Otherwise, they could face potential penalties from the Alberta Human Rights Commission. So it's really important to keep those in mind. So when advertising for a new position, employers are prevented from advertising in a way which discriminates against any of those 15 protected characteristics unless there's a bona fide occupational requirement. So what that essentially means is that you can't, sorry, I'll just move to the next slide here. Oh, pardon me, I'm a little too far. Yeah, so this can kind of include, for example, you can't stipulate that a candidate, must be male or must have a particular religious belief even in advertising. And you also must be careful not to do this in an indirect way either. So if you're putting in requirements for your positions that have the direct effect of discriminating against these protected characteristics, even if you're not doing it overtly, you can still attract liability under human rights law. Now, as I mentioned, there is an exception to this rule, being where there is a bona fide occupational requirement, which essentially means that in order to make an exception, it would cause the employer some undue hardship. which you cannot reasonably accommodate. So this is a bit of a unique area in terms of the law, so it is recommended that you consult with legal counsel before asserting that a bona fide occupational requirement exists when deciding to, make a job advertisement that can contain some discriminatory content. It can exist certainly, but it's definitely something that you want to avoid attracting liability for. So it is best to consult with legal counsel before making that decision. Now, similarly, during the interview process, employers must not disqualify candidates on the basis of those 15 protected characteristics. For example, if a candidate discloses that they're pregnant or plan to start a family in the near future, employees can't refuse to hire an employee based on that basis. Or similarly, if an employee discloses during the interview process that they have a physical disability that requires some kind of accommodation to perform their duties, the employer cannot disqualify that candidate on that basis, and they must make efforts to accommodate those needs if the candidate is eventually hired. This, of course, is still subject to that exception of a bona fide occupational requirement, which was just discussed. So, there are instances where you are able to, say certain labor-intensive jobs where it may be impossible without causing undue hardship to accommodate a physical disability. You may be able to assert that and only hire candidates that don't need those kinds of accommodations. But again, this is kind of a tricky area of the law, so it's best to consult with counsel before making that decision. If you are found to have discriminated against one of those protected grounds under human rights law, you can be subject to a complaint to the Alberta Human Rights Commission. Now, there's some important things to consider as far as liability goes. There can be monetary penalties imposed by the Alberta Human Rights Commission, which often range in from $10,000 to $40,000, depending on the severity of the violation. And also, it's important to keep in mind that these decisions that the Alberta Human Rights Commission makes are publicly disclosed. So you could face some serious reputational damage if you're found to be violating human rights law. Just turning quickly to a real-world example, this is a decision made that started at the Human Rights Commission but went to the Alberta Court of Queen's Bench. In this decision, the Court of Queen's Bench found that the Fort McMurray Catholic School Board of Education had discriminated against two teachers who had both applied for vice principal roles. Now, during the application process, both candidates had disclosed to the board that they were pregnant during the application process. And despite otherwise being qualified for these roles, both candidates were refused vice principal positions. And the court here found that these decisions related solely to the fact that these candidates were women requiring maternity leave, and accordingly, discrimination had occurred in violation of the Alberta Human Rights Act. So it's definitely important to keep these kinds of things in mind. But as I said, it doesn't need to be quite as overt as, disqualifying a candidate over, you don't have to, it doesn't need to be stated to them that that's the basis of the discrimination. If you're engaging in practices that indirectly have the same effect, then you could also be liable under the Human Rights Act as well. So turning towards employment contracts, once a candidate has been selected, the next crucial step is the employment contract. And as we'll get into more detail here, the best employment contracts are written, clear, and most importantly, comprehensive and enforceable. Now, as I mentioned, as a starting point, agreements for employment, they don't have to be, but they really, really should be written. This allows all parties to be entirely clear on what the agreed terms of the relationship will be, which will help avoid confusion and disputes in the future. And written employment contracts also give you the greater ability to tailor your employment relationship to meet the needs of your business, as well as of the employee. When you're doing this, you need to be sure to meet the minimum requirements of Alberta's employment standards legislation. You can't contract in a way that kind of subverts the minimum requirements. But aside from that limitation, you're generally free to structure the employment relationship how you'd like. Additionally, having a clearly worded employment contract will help with avoiding liability under the common law. As we'll discuss more later on, this is particularly relevant when it comes to terminations of employment. If your contract is not written or written in an unclear way, you may be stuck relying on principles created by previous court decisions rather than what the parties have intended to agree to. So in many cases where your employment contract doesn't directly address a situation, when it becomes a dispute, the courts will be forced to revert to how the common law has addressed those situations in the past, as opposed to what you may have wanted to agree to. So turning to what specific terms really need to be included in an employment contract, this of course will vary depending on the nature of your business and the specific employee in question. However, there are some key elements which all employment contracts should include. First things first, the term of the agreement is important. If you're looking to hire an employee for a fixed term only, this needs to be clearly stated in the employment contract, which should include a very clearly outlined, end date for that employment relationship. If you do not include any kind of term in the relationship, the employment will be presumed to be on an indefinite basis, which can attract, different liabilities in terms of severance and things like that upon the termination of that relationship. Next, the employee's total compensation should be outlined. This includes all aspects of compensation, such as base pay, benefits, entitlements, as well as any performance-based incentives that may apply in that situation. Additionally, when it comes to performance bonuses, it's advisable to set out specifically how eligibility to earn and receive that bonus will be measured. This will help avoid confusion and conflict in the future. For example, it's common for employment contracts to stipulate that an employee needs to be actively employed at the time a bonus is paid, rather than just when it's earned. However, if the contract doesn't cover this point, the employer might be required to pay bonuses to departing employees as part of their severance. If the bonus has already been earned, but the employee is not set to be actively employed when it's paid out, they may still be, entitled to that if the contract doesn't clearly set out the requirements for paying out that bonus. It's also important in the contract to set out clearly what expectations you have of the employee. This will include things like their hours of work, what duties they are responsible for, and you should also have them agree to abide by all employer policies, which may change from time to time in that contract. Now, as I previously alluded to, it's really crucial that employment contracts clearly address an employee's entitlement upon termination, particularly in the cases of without cause termination. So there are minimum standards contained in the Alberta Employment Standards Code that set out the absolute minimums what are required in the case of not-for-cause terminations. But subject to these minimums, employers are free to set out specifically what amount of notice or severance pay an employee will receive upon termination of their employment. However, this must be clearly stated, and it must expressly identify that whatever entitlement you're setting out is in satisfaction of all entitlements to notice or severance pay, whether by nature of contract or under the common law. If you fail to do that, then you could face additional liability under the common law. The courts have been increasingly stringent on this point. If the provision is not sufficiently clear, then the employee will be entitled to receive severance pay in accordance with the common law, which generally greatly exceeds the minimum, which does greatly exceed the minimum standards of the employment code, and often will exceed what you had agreed to in the contract if it's not clearly stated. Now, turning to non-solicitation and non-competition provisions. These can also be included in your employment contract. So as a refresher, non-solicitation provisions will prevent a departing employee from going after or soliciting employees or clients of the former employer. And relatedly, non-competition agreements will prevent the departing employee from competing with their former employer by either accepting employment with a competing business or starting their own competing business. Now, in some jurisdictions, such as Ontario, non-competition provisions are generally not permitted for employment. However, in Alberta, we don't have this kind of strict legislation. That being said, in terms of enforceability, it can be a bit of a tricky spot. It's understandable that employers would want to implement these, but they can be difficult to enforce. The courts are increasingly less willing to uphold these kinds of provisions and have gotten to the point where, they begin with the presumption that they are unenforceable until it can be proven that they're reasonable. So to be reasonable, a non-solicitation or non-competition provision needs to be reasonably limited in terms of its geographic scope, For example, what city a departing employee must avoid competing in. They must also be limited in duration. Now, on this point, anything extending longer than a year or two will often be considered to be too long. And they must be limited in terms of the restricted conduct. For example, it may be reasonable to prevent a departing employee from soliciting from current clients, but it might not be reasonable to prevent them from soliciting any potential client of your business. So, if you fail on any of those 3 points, the courts will often determine that your non-competition or non-solicitation provision is unreasonable and it will not be enforceable. The whole idea underlying this is that departing employees still need to be able to earn a living after leaving your organization without moving to an entirely new region or making a career change, and courts are very willing to protect that right. One of the key things to address is ownership of intellectual property. Now, this is particularly important in case of employment where your employee will be responsible for, developing ideas, new technologies, new business processes for the company's use. So it's important that upon departure of that employee, the company retains control of that intellectual property that is created by the employee. So the employment agreement should stipulate that any intellectual property developed in that employee's employment or using company resources will remain the property of the company upon their departure. And this should include a waiver of all moral rights to that intellectual property to ensure that you don't face any, claims of ownership from that employee down the line. So now we are going to cover some employer policies. And at this point, I will turn it over to Christin to begin presenting. So just bear with me a moment while I give her control.
Great. Thanks so much, Colton. Excellent. So we're now going to move into talking about employer policies. We could probably do an entire hour-long or longer presentation on employer policies. So we're not going to get into a lot of detail on these, but we're going to outline some of the more important ones for you to make sure you have in place. So generally speaking, to start with, you want, as Colton mentioned, all employees to agree to abide by and follow the policies and procedures you have in place as a term of their employment. So you want it in their employment contract that they are agreeing to do that. Otherwise, it might not form part of their terms of employment. And if you were wanting to institute some policies and procedures down the road, you might have to actually provide that employee with additional consideration in order to do so, because it could be seen as a fundamental change to their existing employment contract that doesn't speak to them. So really important. This means that as part of the onboarding process, employees should be presented with the policies right away, instructed to review them thoroughly, and then they should sign off to confirm that they actually understand those policies. So generally what we see is the policies, most of them, the human resources type policies, are compiled into a bit of a handbook, and then there can be kind of one sign-off page at the end of that handbook for the employee to fill in. It can be digital or physical copy. That part doesn't matter so much, but just important to make sure you're getting them to sign off so that down the road you have that evidence that they were aware those policies existed. This is particularly important if an employee is disciplined for violating a policy down the road. If they never saw the policy, were never given access to it, you're not going to be able to validly discipline them for something they've done in violation of that policy if they weren't actually aware of it. So that's why it's very important. In terms of advisable policies, we're going to talk about a few today. There are other policies that might be important for your business, depending on the nature of the business you're in, as well as maybe other issues you've had come up in the past. These are kind of just a sample of the most important type ones from our perspective, as well as a required one under law. So we'll look at harassment and violence prevention, safety protocols and procedures, confidentiality, conflict of interest, use of technology, and a fit for work type of policy. So harassment and violence prevention policies. The legislation in Alberta, the Occupational Health and Safety Act and the code require that an employer actually have a harassment and violence prevention policy and procedure in place, as well as the overriding obligation under occupational health and safety law to provide their workers with a safe workplace. So this is just really a piece of that, and it's gotten more specific in more recent years around harassment and violence. So you want to make sure your policy and procedure comply with the requirements of the legislation. It's mainly found in the Occupational Health and Safety Code. You want to, as part of that, include a clear definition of what is going to constitute workplace harassment and workplace violence so that people understand if they see it or experience it, what it is. You then also want to commit that as an employer, or state that as an employer, you are committed to preventing workplace harassment and violence. That's an important and required piece. And then you want to set out thorough reporting protocols that set out exactly how an employee goes about reporting if they've either witnessed workplace harassment or violence or if they've experienced it, what that process is so that they can easily look at the policy and procedure and figure that out. You also want to include as part of that there will be an investigation done if it's reported and not resolved in some other type of way, and how that investigation is sort of going to unfold at a high level in terms of that process. Sorry. You also want to, and I'm going to repeat this with every policy pretty much today, so just bear with me. I'll sort of explain it here and then we'll just gloss over it on the other ones. Really important to set out the potential consequences for violating the policy. So you want to set out that if the policy is violated, if someone acts contrary to what the policy and procedure set out, then they may be disciplined up to and including termination for cause. That gives you the basis later to actually impose that discipline if there is a violation of the policy that's proven to have occurred or demonstrated to have occurred. The next policies are safety protocols and procedures. Sometimes these are housed in a separate occupational health and safety manual or safety manual. The titles vary depending on the workplace. They're particularly important in safety-sensitive workplaces where there is operation of heavy equipment or machinery, but they're also important in environments that aren't particularly safety-sensitive because there are still situations that could arise that may involve safety issues, and employees need to be aware of how those will be dealt with and what the employer is doing to try to prevent, to keep the workplace safe, I guess is a better way to put it. So you want to set out procedures for identifying and minimizing the risk of any workplace hazards that may exist. That may include requiring that employees use personal protective equipment or PPE for certain jobs or tasks. If that is the case, it should set out what that equipment is. Generally helpful as well to make sure employees are aware of where that is. It might not be right in your policy, but it should be easy for them to find out, or there could be a contact person if they're not sure. You want to have procedures set out for how employees go about reporting or addressing workplace injuries, not just for occupational health and safety reasons, but also because of workers' compensation requirements, unless you are an exempt business when it comes to workers' compensation legislation. And then again, you want to set out that the employee may be disciplined up to and including termination for cause if they violate the policy or don't act in accordance with it. Confidentiality policies. And I don't think we mentioned this in the employment contract context, but it is important to actually speak to the obligation of confidentiality in the employment contract. Now, there is an obligation at common law on employees to keep the confidential information belonging to their employer confidential, and that obligation does survive termination. However, that's a pretty vague obligation, so they don't necessarily know what confidential information is in the context of that employer, how they might be able to use it or not use it, and how it might be able to be disclosed or not disclosed. So you want to set that out to some degree, at least in the employment agreement, that there are those obligations, and it can refer back to a policy that speaks in more detail to confidential information and what it includes. So you will want to include things like product information if you happen to be a product-driven company, trade secrets if there are any, financial information of your organization, employee personal information, really important to protect that because of privacy legislation as well. And then also any client information. Again, privacy legislation can also come into play there. So you want to make sure you spell out that those things are need to be kept confidential and can't be used or disclosed outside of, doing something for the business or the organization. Conflict of interest policies are also quite important. They're really designed to make sure that employees aren't acting in a manner that's going to be adverse in interest to the employer. So you want to include a few things in this policy. One is you want to make sure there is a clear definition of what is considered to be, or what might be considered to be, a conflict of interest. This might include something like if the employee were to moonlight in a second job for a competitor, that would be seen as a conflict of interest, at least for most businesses. There may be some times when that doesn't apply, but for a majority of businesses, that's likely. Or if they try to take a business opportunity that properly belongs to the business, that they learned of through their job, the business would otherwise maybe be considering, and then they take it for themselves. Those are a couple examples. But you want your definition to be clear enough that employees will understand, I might have a conflict of interest here, and that means I probably need to tell someone about it. Because you also want your policy to say the employee is going to avoid those conflicts of interest and that they're going to disclose any potential or actual conflicts of interest that might come up. So again, if your definition triggers them to go, this might be a conflict of interest, I'm not sure, then they know they have to report that and who that should be reported to. And then finally, again, you want to outline the potential consequences for violating that policy so that if you need to discipline someone for violating it, you have that basis right in that policy. Use of technology policies, technology just seems to keep expanding and growing around us at rapid rates, and it's generally required for most employees to do their job at least to some level. It's important to make sure that employees are using that technology at work in a responsible manner. They're not doing things they shouldn't be. They're not doing things that could make the employer liable for anything else, or that could disclose confidential or business information that shouldn't be getting out. You may need to include in your use of technology policies limits on the use of technology in the workplace. I would recommend that you do. Not just the physical computers, phones, those kinds of things, but also software, and in the world we're in today as well, AI technologies. They might be very helpful for certain jobs and for certain tasks, but you want to make sure employees are using that properly. They're not disclosing confidential information or other business information, proprietary information, or personal information that might belong to someone else, because with the way AI functions, that could ultimately be accessed by someone else if they do. So you have to make sure employees are aware of how to use it responsibly. And then also, we always recommend that there be something in the policy speaking to acceptable use of social media by the employees in terms of work, or perhaps the work social media if they happen to have access to that in their role. The last policy we're going to talk about briefly is the Fit for Work policy. So this one, it can also be called a drug and alcohol intoxication prevention, or there's a number of different ways this might be titled. I just like Fit for Work because it can also then include some other things, but I'm mainly going to focus on the drug and alcohol piece of it. So you want to make sure it addresses kind of every possibility for alcohol, illegal drugs. By legal drugs, I really mean cannabis at this point for the most part, prescription and over-the-counter medications. This is because you need employees to report to be as in a condition that is fit for work. So particularly in safety sensitive workplaces, but also in an office environment where they may need to be able to do complicated tasks using their brain, maybe not with physical big equipment, still important. And if they may be affected by something they're ingesting or using, that's something that needs to be dealt with. So the policy should also make it a requirement that the employee report if they're taking any prescriptions or over-the-counter medications that could cause them to not be fit for work. So if the medication will make them drowsy, will prevent them from operating heavy machinery, and that's their job, those kinds of things. You may not be entitled to know the actual name of the medication, but you will be entitled to information about the side effects of that medication and whether they will be a factor during that employee's workday. You're going to want to get more information on that, really, but if it is reported. You also want to specify that if an employee believes they may have an alcohol or a drug dependency that might interfere with their ability to be fit for work or will, that they report that in advance of any kind of an incident happening. And the reason you want that in place is that way, if there is an incident and they happen to test positive for some kind of substance, you can then go back and say, well, you didn't report under the policy. That's a requirement. And so we're terminating you for having violated the policy itself, so you can separate it from what might be a human rights aspect, because a substance dependency can be part of a disability, right? So we can separate it out from that human rights aspect and say, no, this really has to do with the fact you didn't report before the incident happened, and therefore your employment's being terminated, or you're being disciplined on some other level because you didn't comply with the policy. And there's case law around this requirement. So that's why it's really important. And you will also have to spell it in the policy that if an employee does report, that they will be helped by, maybe being sent to the employee assistance plan for an assessment, and then perhaps, the employer will assist them to get the help that they need, not necessarily paying for it, but going through that program or another one to help the employee, so that you're accommodating that disability generally is how it's viewed under human rights legislation. And again, important that you've spelled out the potential consequences for violating the policy directly in the policy, if that is, if discipline is going to come up down the road potentially. So moving on from policies, and like I said, really I could spend a lot more time talking about all of those policies because they are important, and there's a lot of information that should be included in them, and maybe some things that shouldn't. But we're going to move on to onboarding new employees and that process a bit for now. So what are some important steps to take during onboarding? Well, I expect you all, probably generally know this anyway, but it's really important to get off on the right foot with the employee, to make them feel welcome and valued when they're starting. That's really going to set that relationship off on the right foot, not just from a legal perspective, but also from a practical perspective. You really want them to come in and, sort of be excited and looking forward to working and getting the information they need to do whatever it is they've been hired to do. As I mentioned already, with the policies, you want to present those and get them to sign off on them right away so that they can't later come back and say, well, I didn't know about that policy. No one told me about it, or that I couldn't do this as a result of the policy. So you want to get that taken care of right away. It's also really important to provide all necessary training and resources for whatever it is that employee's role is encompassing. It's particularly important if you've outlined any kind of specific training or access to certain resources in their employment agreement, because then you're contractually obligated to give that to them. But as well as it's important because if you don't provide the necessary training and resources, but you expect them to do the job, and then you end up perhaps terminating them down the road because they're not doing the job, or you're consistently on them for not doing things properly, but they're not being told how to do things properly or what the expected processes or the expectations are. That could lead to a claim, either if they are actually terminated by you for wrongful dismissal, or if they're not terminated, but they are just not being given what they need to actually do what they're being asked to do. That could be a constructive dismissal. And so that's important as well. The other piece of this is that if an employee who's been hired, or even a candidate, at the offer stage or at any point, we've already talked about the interviewing and application process, but beyond that, if they disclose some kind of a disability or some other protected ground that might require accommodation, such as a religious belief or a family status obligation, then you need to get more information about that in order to be able to implement necessary accommodations. So the consequences if you don't onboard effectively, practically speaking, are, the new employee might feel disengaged and isolated if you haven't integrated them into the organization. And that's not a good way to start an employment relationship. A failure to provide them with the policies might lead to that policy not really being enforceable against that employee if you're looking to discipline them down the road or anything like that. If you don't provide the necessary training and resources, that can lead to poor work product, and maybe they're not being very efficient or productive for you at that point because they don't know exactly really what they're supposed to be doing. It can also then, as I mentioned, lead to claims of constructive dismissal. And then if you're dealing with human rights grounds that require accommodation or might require that you assess if there's accommodation required, Failure to do that can lead to human rights-based complaints as well, and could also support a constructive dismissal claim. So you might end up dealing with both of those if things aren't done properly. Human rights complaints. So Colton mentioned these a little bit. I'll just mention it again. Important to note that these can only be made within 1 year of the violation occurring. So if the employee is terminated, or if there's a constructive dismissal and there's sort of a date that can be determined of when that occurred, usually that means the employee resigns. It says they were forced to quit, then they have 1 year from that date. If it's an ongoing kind of violation, like a failure to accommodate, then it'll be from the most recent incident that was part of that kind of ongoing course of conduct. That's when the 1 year would kind of start to run from. The Alberta Human Rights Commission, as Colton mentioned, has pretty broad powers. So if an employee is actually terminated, they can reinstate that employee to their job. The courts don't have that ability with a wrongful dismissal or constructive dismissal claim, but the Human Rights Commission, or it would be a tribunal making the decision, does. So that's an important piece to recognize. The other thing is they can impose orders like requiring that the discriminatory practices cease. They can require that certain training be undergone by the organization related to human rights. They can require that policies be updated or changed or put in place if they don't exist that relate to human rights type issues. So there's really a broad power there. In addition, as Colton mentioned, they can award lost wages and general damages for suffering an injury to dignity. Now, lost wages can be a significant number. Let's say an employee is constructively dismissed and then they bring a human rights complaint, but it takes 3 years to get to the tribunal. They would be entitled to, generally, the awards are for lost wages for that entire period from the date that they are done working for the employer as part of the constructive dismissal to the date of the tribunal hearing. Now, it's not always that full period of time if there are indications the employee was sort of just sitting back waiting for an award or something. And if they get another job, then generally any earnings that they have during that period of time would be deducted from the overall award, but the numbers can be quite significant. So that's something to keep in mind, a lot more significant than just a wrongful dismissal or constructive dismissal claim in some circumstances. And the general damages for suffering an injury to dignity, I think Colton said, can range between $10,000 to $40,000. Sometimes they will be a bit lower, around 7 to 8, but I wouldn't necessarily count on that. And we have seen them go as high as $50,000 in Alberta, generally for quite extreme cases. Most cases at the higher end up, I would say, more around that $25,000 range, but there are more and more that are going beyond that as we move forward. So important to keep those in mind as well. And then for constructive dismissal, an employee has 2 years from the effective date of that constructive dismissal to file legal action, or else they will be statute barred from doing so. Constructive dismissal happens really where the employer shows they no longer intend to honor the employment relationship. Often what I say is it's basically the employees being forced to quit, either by significant changes to the terms of their employment, by being put in a toxic workplace, which could, in some cases include being asked to do a job but not instructed on how, and then constantly being spoken to or disciplined about not doing that job properly. And that really applies in our onboarding situation. So that can be seen as a constructive dismissal or held to be by a court, even though the employer hasn't technically actually terminated the employment by saying, you're terminated. There's still an award for damages. It's the calculation of damages is the same as if it was a termination without cause by the employer. So it's, damages for the reasonable notice period based on what the employee would have earned if they'd worked that period of time. And then potentially on top, punitive or aggravated damages. We see punitive and aggravated damages a little more often in cases dealing with a constructive dismissal because of the behavior that's sometimes going on that leads to the constructive dismissal. So that's something to keep in mind as well. And those damages can be in the tens of thousands of dollars. They have gone into hundreds of thousands, but again, usually in quite extreme cases of behavior. So probably more like tens of thousands of dollars. But then there's also the time and the money that's put into defending against either a human rights complaint or, legal action if that's where things end up. So just as a brief real world example, we have Smorhay and Goodfellow law. So this was a decision of a human rights tribunal in Alberta in 2021. The employee had been employed as a legal assistant for only 3 months before she was terminated from her employment. Now, the employer claimed that her termination was due to performance issues and a large number of absences. However, the employee had disclosed to the employer that she had childcare obligations that had led to some absences, as well as a medical issue that had led to some of the absences. Now, despite being advised of those, the employer didn't take steps to reasonably accommodate the employee in terms of that medical situation, which constituted a disability in this case, and the childcare obligations, which fell under family status and met their requirements there. As a result of that, the tribunal held that the employee had been discriminated against and not properly accommodated, and that was in violation of the Human Rights Act. And the employee was awarded 13 and a half weeks lost wages, plus $15,000 in general damages for injury to dignity. So that's those additional general damages. So not a small number. Again, there would have been time and effort and money invested into even getting through and up to and then through the tribunal hearing. So not a situation you really want to find yourself in. Now, the other thing I want to mention briefly with new employees is you want to make sure that you include a probationary period. Under employment standards legislation in Alberta and also federally, employees do not have a right to notice of their termination or any pay in lieu of that notice of termination if they're terminated within the first 90 days of their employment. Now, that's under the statute. At common law, if you haven't expressly limited their entitlements during that probationary period in the employment agreement, then they may be entitled to damages in lieu of notice. Generally, I think for a probationary employee, that might not be very long, but it could be. We've seen short service employees get, 3 months, even though they've worked there less than a year. So important to keep that in mind. In your employment contract, you want to specify that if they are terminated during that first 90 days, they have no entitlements, either under the statute or at common law. Now, you can't extend the probationary period and avoid the statutory obligations to provide termination notice or termination pay, but you can extend it in the sense that you could specify that if they're terminated during an additional probationary period, they're limited to only their entitlements under the applicable employment standards legislation. So you could structure it that way if you were dealing with a position where a longer probationary period was appropriate. Also, this does usually line up with benefits eligibility, which usually is a 3-month waiting period. 90 days versus 3 months, it could be a difference depending on the months we're talking about, but kind of lines up so that you don't have to go through getting them in on the benefits plan necessarily if then they're let go before that time is up. So the probationary period is a really good time for an employer to assess the employee's fit within the organization, and it gives you that kind of the potential liability for ending the relationship is low if you've properly set out that probationary period in the employment agreement, in addition to relying on the statute. It is advisable, and I have employers sometimes contact me, it'll be over 90 days, it'll be 4 months, maybe after the employee started saying, well, they were never very good at this job. And I'm like, well, if you'd come to me a little earlier, if you'd kind of assessed this a bit earlier, you could have terminated them during the probationary period. You wouldn't have owed them anything, but now you owe them something more. If there's a good termination clause in place, then maybe it's not a lot, but, and it can take time to deal with that too. So, really important to be assessing that employee's performance, to be giving them information about their performance so they can try to improve, and assessing it before that 90 days comes to an end, so that if, you're getting close to that 90 days and they're still not getting to where they need to be, and aren't showing improvement, that you can then end that relationship and have it fall within that first 90-day period. So a real world example of a probationary period kind of gone wrong is Lee and British Columbia. This was dealing with the Interior Health Authority, and is a decision from BC in 2017. So the employee only worked for the health authority for 2 months before their employment was terminated. There was a probationary clause in the employment agreement, but the wording required a good faith assessment of suitability for continued employment. Now, unfortunately, the health authority was not able to demonstrate that they'd actually made this good faith assessment of suitability. And so as a result of that, because of that language being included, they couldn't rely on that probationary clause to limit severance entitlements, even though the employee was terminated in the first 2 months after the first 2 months of employment. So ultimately, the court awarded that employee 3 months pay in lieu of notice. So he only worked there for 2 months and then was awarded 3 months pay in lieu of notice. Plus, he was awarded additional travel and relocation expenses. So it's particularly important, I would say. I think it's always important, but particularly so if you have an employee who's relocating for a job, that you have that probationary period spelled out in there. So that it's very clear, because those expenses could be pretty significant if, as a company or organization, you haven't actually covered those for the employee at that stage, or maybe you haven't covered all of them. Maybe it's only a small part. So that can lead to that additional kind of liability in that circumstance. So, some key takeaways for today. Important to keep human rights law in mind when you're advertising and interviewing for positions, because they do apply, as well as during that onboarding and hiring process, because there can be a need for accommodations at that point if someone discloses they require some kind of accommodation based on a protected ground. Important to have written employment agreements. You can verbally make them, but really hard down the road to say what was actually agreed to when it's verbally agreed to. So please make them written employment agreements, and make sure they're clear and that they're thorough, and apply to the specific situation. The problem with just pulling a template from somewhere is they might not actually apply very well to where you're at that point in time. And then you also need to have clear policies that address your needs, and make sure employees are agreeing to at the outset of their employment and signing off on the policies. I'm also going to throw in, although we're talking about hiring and onboarding, if you update those at any point, if you put into place new policies, making sure employees are also reviewing them again, reviewing those new ones, the updated ones, but also regularly if it's been a few years that they've been employed and you haven't maybe updated anything, but they haven't looked at the policies in a while, always good to give them a refresher on those and have them sign off again, so they can't say, oh, well, it was 10 years ago that I last saw these and I haven't looked at them since, and I don't know how to access them, or those kinds of things. So just another piece that I think is a good bit of advice. And then make sure you have a strong onboarding plan in place for how that employee is going to be onboarded, what training and resources are going to be provided, that they need to sign off on the policies first, provide them information about their benefits, compensation, all those kinds of things as well. That's really going to help ensure the success of the new employees in their roles and help to avoid potential legal liability down the road if things don't go well. Okay, and that concludes our presentation, but we've left about 10 minutes for questions. So if anybody has any questions, you can pop those into the Q&A, and Colton and I would be happy to answer those for you. Yeah, so I don't think we have any questions at the moment. I'll give people a minute or two to sort of type that into the Q&A. If you have any questions about what we've spoken about today, happy to answer them. Otherwise, we will certainly let you go if people don't have questions. Oh, here we go. So we have one question. During the interview process, can an employer ask a potential employee if they are working within a time-sensitive work permit? So there's a situation where an employee was hired and their work permit was expiring 3 months after that employee started. So you can certainly make it a requirement of employment that the employee be validly able to work in Canada. I would not recommend asking them if they are here on a time-sensitive work permit directly in that interview. You can ask, I think, you can say, are you or will you be able to be legally work in Canada? That's okay. But if you get into the work permit question, you can get into questions of, okay, are you going to discriminate based on where the person is from, or potentially race or color or those kinds of things. So you have to be really careful about those questions. But you can make it a part of, if you're going to offer employment, that the employee is required to have any required documentation and to be able to work in Canada by the start date. They may not be at that moment, but as long as they are able to by the time they're starting, and putting that responsibility back on the employee, that is okay. Okay. I'm not seeing any other questions unless anyone has a follow-up on that one. So I want to say thank you very much for coming today, first of all. We really appreciate you taking the time to join us. As well, we will be sending out a copy of the recording from this session, as well as the slides afterward by email. We'll also be including a link to a really short survey. We're just asking that you provide us with some answers. It helps us improve the webinars as we move forward. And we also include a section where you can suggest topics. So if there's something you would particularly like to hear about, or maybe like to hear more about, then please pop that in there, and that will help us decide what to do from on an ongoing basis kind of in the future, and we can go from there. So
Christin, I think there's one more question in the Q&A as well now. I can read it out to you if you'd prefer.
Oh, perfect.
Yeah, so we got a question saying, is it reasonable to ask a question such as, can you describe anything that could limit your ability to perform the duties of this position that are outlined in the job description?
Yeah, I think that's a permitted question. Now, recognizing if an employee discloses that they do have some kind of disability or something, and they may not tell you exactly what it is because you're not entitled to know technically the specific disability, but they might disclose that they can't lift over X number of pounds or do those kinds of things. There could be an obligation to sort of ask for more information and to accommodate, right, that person. You can't just not hire them necessarily. If there is any protected ground at play, you have to be careful about how that decision is made. So I think that question is okay because it could just be a personal thing they reveal as well. But you have to you do need to be careful about that as well, because it can trigger that obligation to sort of accommodate and not discriminate against that person if there is a protected ground at play. Thank you for that question. Okay, I'm not seeing any more, so please keep an eye out for that email. And if you have colleagues that registered as well, we will be sending the link out to the recording out to them and the slides as well. So you can let them know that. And once again, thank you for joining us today, and we hope you enjoy the rest of your day.